Hello everyone, this is Brian Ka with another video to help you pass the California Baby Bar. So I've been thinking about whether studying for the essay portion, the Baby Bar no longer has essay questions, but for the sake of the discussion for the future exam, in my case, which would be a general bar exam, I was thinking that studying for the general bar exam essay questions will probably not be sufficient to help you pass the MBE portion of the test. Now, I'm not sure if you've heard of the changes that the California Bar or the Supreme Court has made regarding the bar exam. One of them is that starting, I believe, next year, because there are two exams per year. I'm not 100% sure whether it's February or October, but for sure it's given twice a year. And to my knowledge, all the MBE questions were written by the Committee of National Bar Committee or some other name that is similar to that. But starting, I believe, like in 2 years after they work everything out, Kaplan is going to write the test, and I'm sure there's going to be input from the people who are from the committee of bar examiners, but mainly, according to some sources that I listen to, it's going to be written by Kaplan now. And I'm not sure if that's going to be beneficial for us. I'm not sure if that's going to make these tests harder. But regardless, back to my first point that studying for the essay portion is probably not enough to get you a passing score on these MBE questions. The reason why I say that is because after reviewing many MBE questions and reviewing many essay questions, because I went over every single essay question for the baby bar exam, and so far I've reviewed some bar exam questions also, but it is, to me it seems like the essay portion is easier. You may disagree, but for me it is easier. The reason why it's easier is because for the essay portion, you just have to have a general knowledge of some black letter law, meaning as long as you know the basic elements and some exceptions to the rule, then that will be enough to get you a passing score. Some people say passing is 65, some people say 70 and up, and I'm not 100% sure. But knowing general law and some exceptions will not be enough to get you a passing score on the MBEs. Now, MBEs are different because they ask you about one element for, let's say, conversion. And they ask you like whether that one element of conversion will apply to a certain fact pattern, and you have to know whether or not that fact pattern fits one of the elements of, let's say, battery, assault, conversion. So these MBE questions are not testing you whether you know the general law or the exception. They're not testing you whether you're able to analyze using the facts at hand and whether you're able to conclude using everything. Now, again, going back to the MBEs, they're not asking here, MBEs, for your general knowledge of the law. Usually, what happens is they pick out an element and they want you to know, again, whether that element can be used or it fits the fact pattern at hand for a person to be liable for something that they're asking. So it makes sense that when you see people talk about how they passed the bar exam and how they studied for the MBE portion of it, they may just go through Adapti-Bar and just hammer out every single question, do as many as you can. But there is a person that I saw, and she said that every question that she got wrong on the Adapti-Bar, she wrote out the rule pertaining to that question. So if she did like 100 questions and she got 30 of them wrong, she would look at the answer, copy and paste the law that pertains to that question. So she ended up making a list of bunch of rules for each subject in which she failed to answer successfully on that question. And before the bar exam, she reviewed every single question like that. And that makes sense because, again, because MBE questions are asking you for certain nuances or details of each black letter law, you're not going to pass by just knowing the general or the exceptions to that rule. So you really have to understand each element, like if the element has intent, for example, you have to know or distinguish whether that means criminal intent or if it just means that without harmful or criminal intent, whether that intent just means, for example, like trespass, as long as a person has intent to trespass or intent to touch somebody without intent to harm or injure, you have to know whether that is sufficient to prove the intent element of that tort. So, like I said, the best way would be to do as many questions as you can. And I was thinking about this. I was thinking that although bar max was good enough for me to get me a passing grade on the baby bar exam, they don't have that many questions. Like for example, for torts, I think it was like 200, 300 for contracts, probably the same criminal law, a little bit less. So if you add everything together, it was about 1,000 questions. And that's probably not enough to expose you to many scenarios and many situations, because exposing yourself to as many questions as you can, and when I say questions, I mean legit questions, not some like weird questions that somebody made up. I don't mean that. I mean like legit questions that are very similar to the questions that they tested on in the past. I think that would be very beneficial. So make sure to expose yourself to as many questions as you can, so that when the test time comes, you would have seen everything. You saw a question that asked about a similar thing, just in a different fashion. And I think that's where you want to be at once you're ready to take the bar exam. And I'm already trying to go over as many questions as I can. I mean, I have some plans to, after, because I'm in my second year of law studies, I'm thinking like my beginning of my fourth year, I am probably going to apply for an internship at the public defender's office. And I'm not really sure if that's going to work out. And in life, things don't always work out the way you expected them to, but that's on my mind. And the reason why I want to do that in my fourth year is because I want to really make sure that I have the confidence that I'll pass the bar exam. And the fact that I already went through the baby bar exam, and I kind of went over everything and how I need to study for the upcoming bar exam. I think that it was only good. There was only good in it, nothing bad about it. At the time, before failing it one time and waiting 10 years to retake it, that was painful. But looking back at everything, all the situation together, I think that taking the bar exam, baby bar exam, did nothing but good. So, I mean, if you don't have to take it, then, all powers to you. You know, if you had good grades, you know, aced the LSAT, and you ended up going to a phenomenal law school, nothing but respect to you. But there's certain people like myself who just didn't, who are not good standardized test takers. And I don't think that means that we're less smart. I think it means that we are gifted in other ways. I may be more creative than some people, whereas some people are may not be as creative, but they're just able to look at something and regurgitate it so that they can pass any tests. And I don't think that is a good indicator of whether how smart you are. Maybe it's a good indicator of whether you can follow directions and understand the thinking behind people who write these tests. But I'm not trying to say that people who had to go to 4 years, 4-year law school as a result of just not understanding how to pass, do well on the LSAT, and maybe your college grades weren't as high as you would like to be, but later on you really started focusing, and you did phenomenal in law school. And I don't think that there is a right or wrong answer here. It's just that people all go through different things in life, and some people may have gifts in one thing and not the other. So that's that. And with that, let's do questions 33 to 42 today. And hopefully, in another 4 or 5 videos, we can do all 100 so that you can have somebody that talked about these questions, although they may not be 100%. When a person who teaches the bar exam may notice something that I've said that might not be 100% correct, but I'm trying my best to rehash everything according to my knowledge, and I am not perfect, but I'm just doing this as a tool for, or a guidance for you to use in case you don't have the means or you don't have the resources to pass the baby bar exam. So with that, let's start with 33. Okay. So actor, a well-known film star, was photographed by a freelance photographer while sitting at a sidewalk cafe drinking beer and with a bottle of famous light beer on the table in front of him. The picture was reproduced in magazine, a publication containing stories and articles about the film industry in connection with a story about the eating and drinking tastes of film stars. The label on the beer bottle was clearly visible in the picture. The following month, advertisements for famous light beer appeared in other publications and carried a reproduction of the page from magazine on which actor's picture appeared, with the heading "Drink the beer that movie stars drink." So they're talking about a movie star, a well-known movie star, that was photographed while drinking a beer called Thomas Light Beer, right? Well, this picture was taken by a magazine, and that magazine is a publication that has stories and articles about the film industry, right? But one thing that I noticed here is that they have two defendants or two possible defendants. And I can see that this is going to be like a privacy tort question because they're talking about a magazine and they're talking about a beer company called Thomas Light Beer, which used the actor's picture, right? Drinking that beer for commercial purposes. So it's obvious that it's probably going to be a question of that sort. So let's look at 33. If actor asserts a claim against magazine, will actor prevail? I think the most confusing thing about this question again would be whether you're seeing this question through the lens of the magazine company or the beer company, right? Because usually there is a defense called qualitative privilege, not an absolute privilege. And what it is usually for absolute privilege to work as a defense for privacy torts like appropriation, false light, even defamation. An absolute privilege would be in situations where, like a senator or like a congressman made some speeches while working in that duty as a politician, and or judicial proceedings, like maybe a judge was speaking in a court of law, and maybe he said something or she said something that might have kind of hurt the feelings of an individual, and he found out about it, right? Well, for absolute privilege, judicial proceedings, as well as like congressmen or senators speaking while they're working under the duty of that job, they have the privilege or defense of absolute privilege, which kind of makes them immune from lawsuits. Now, when you talk about qualitative privilege, that applies to like newspapers or magazines that write things or they create articles for the public. Now, if they wrote something and if the other party felt like the person or the company, like a newspaper company or a magazine company, if they wrote something maliciously, then I believe the plaintiff may have a case against them. But unless they can prove malice, generally magazines that cater to the masses or newspapers can use this privilege. So let's look at the answer choices. Let's pull up. Okay. If actor asserts a claim against magazine, will actor prevail? And also the fact that this is a more of a bigger issue in defamation cases, whether or not the person being who is suing is a public figure. And I'm sure you've read New York Times v. Sullivan case, in which for a public figure to prove defamation, they have another hurdle, and that would be like they have to prove malice, that the defendant acted with malice. So the fact that the magazine was dealing with a public figure makes this lawsuit even more difficult, in my opinion. So if the actor asserts a claim against magazine, will actor prevail? Well, Probably not, because of the privilege that magazine companies and newspaper companies have. And there's no indication here of any kind of malice, acting with recklessness or substantial disregard for the truth. The fact pattern would have had something that mentioned this, but it doesn't. So generally, this privilege will be valid. Again, if there was any type of maliciousness on the part of the magazine company, then this public figure might have had an argument there. But because we don't have that, the magazine company's defense will probably prevail. So, with that in mind, A says, yes, if actor had not authorized any use of the picture, well, we already said that no, right? So let's look at B. Yes, because magazine was using actors' picture for its commercial purposes. Well, magazine could use actors' picture for its commercial purposes, right? The business of magazine is to kind of publish, especially this magazine's job is to publish things that are in the interest of the public. So the fact that it was using its picture for commercial purposes, if the beer company was using it for commercial purposes, that would be a big no no because they're not in the business of publishing. But this question is asking whether the magazine a case against magazine will prevail. So because we've decided that probably not, it'll probably be C or D. So let's look at C. No, because actor's picture was taken in a public place, right? Because if it was taken in a private setting, then that would be illegal because a person in a private setting would have the expectation of privacy, right? So if you're taking a picture of somebody who has an expectation of privacy, that would violate his rights. So that wouldn't be that would be actionable. But if we're talking about a picture being taken in a public place, and on top of that, we're talking about a public figure, and on top of that, we're talking about a magazine company who's got a privilege to publish newsworthy articles for the public. So C is probably right, but let's look at D. No, if actor's career was advanced by the publicity. Well, a person's career being advanced doesn't really have anything to do with privacy torts or even defamation, right? Or even any defenses that may apply. So the correct answer would be C. No, because actor's picture was taken in a public place. Number 34. If actor asserts a claim against FOMA's light beer based on the advertisements in the other publications, will actor prevail? Well, here we're not talking about the magazine company. We're talking about the beer company. Now, when a company like a beer company or any other companies that may not have the privilege to use defenses like absolute or qualitative privilege, they would usually be liable for appropriation if they were using a picture of a celebrity without their consent, and if they were using it for commercial purposes. Because when you're using somebody else's likeness and you're using it to gain an advantage in the marketplace, then that would be using somebody else's, image or likeness to further your commercial business, and that would not be they would not be able to escape liability because, again, it was used without consent and it was used for commercial purposes. So let's look at a yes, if actor had not consented to having his picture taken. B, yes, if actor had not consented to film a light beer using actor's picture for commercial purposes. Well, A is like a part of B because it talks about consent. But if you're asking me whether A is a better answer than B, it's not better answer because I mentioned exactly two things that B is talking about. I talked about consent and I talked about commercial purposes. A just talks about consent, B talks about consent and commercial purposes. So that means B is the right answer, right? C says no because actor's picture had already appeared in magazine, which has no relevance. No, if actor was already a public figure. Well, even if they're a public figure, if you're using their picture for commercial purposes, there's got to be some kind of a contract. Without that, that would be an appropriation, a privacy tort, and that would be actionable. So the question here, answer would be B. All right. So V loaned Dan her car when Dan told V that he needed the car in order to get some groceries. In fact, Dan intended to drive 100 miles to apply for a job in city and return the same day. However, when Dan reached city and obtained a job, he decided to remain in city permanently. Dan did not inform V of where he was and he did not return to car to V. Did Dan commit larceny? Well, larceny is usually an easy tort, or I assume that it was easy, but there are certain nuances within that tort that can kind of make it confusing. And this question is asking for timing because we know that when you're talking about larceny, it's wrongful taking or carrying away another person's property, and on top of that, you have to have the intent to permanently deprive, right? And in this question, it's not really clear when the taking and carrying away with intent to permanently deprive occurred. Because if you look in the beginning, he asked to borrow a car to get some groceries. What was his intent? His intent was actually to drive 100 miles to apply for a job and return the same day. Now, because larceny intent needs to be the one where you need to have the intent to permanently deprive of that person's property, when he when his intent was to return the car the same day, even though he lied about going 100 miles away instead of going to the groceries, that would still not be sufficient to establish that he had an intent to permanently deprive. And then it talks about, however, when Dan reached city and obtained the job, he decided to remain in city permanently. Well, still, they're talking about him getting a job and deciding to remain in city permanently. Does that still establish him intending to deprive the car permanently? Well, I don't think so, because even though he decided to remain in city permanently, it's possible that still intended to return the car. The facts don't really say anything about it, but it can be either or. He could have, intended to return the car, or he could have intended to keep the car. The facts are not clear. But when you read on, they tell you that he did not inform V of where he was, and then he did not return. Uh, he didn't return the car to V, right? So when he didn't intend to return the car, that right there establishes his intent, which was to permanently deprive. Before that, it was kind of iffy, right? It was iffy whether when he got the job, he wanted to keep the car or return the car. All they said was that he wanted to remain inside the city permanently. But here, when the facts tell you that after that he decided not to return the car, then right there larceny was established. So we don't know what the answers are going to get or say. So let's look at A. Yes, because Dan did not return the car to V. Well, we just talked about the larceny being established when he decided not to return the car, because prior to that, we don't really know if he still wanted to return the car. So A is probably right. B, yes, because Dan unlawfully converted property to which he had lawfully obtained possession. I'm not sure why they're talking about conversion here. That's the first no no. And the fact that he unlawfully converted to which the property to which he had lawfully obtained doesn't really matter, even though that sounds like an okay answer. C, no, because there was no concurrence of actus reus and mens rea. I know that even Barmax kind of taught us about concurrence. It needs to be it needs to happen at the same time. But I mean, even in some larceny cases, even if you had a lawful intent, but later on you decided that you wanted to steal the car and you acted upon it, that's kind of a situation where if you judge every criminal law case to see if there's concurrence, that would be a very confusing thing, right? So concurrence, Yes, it's needed, but there are exceptions where if you're only looking for whether there was concurrence, there might be some exceptions which might even confuse you even more. And C what was it was okay is okay, but it's not really giving you the reasoning behind whether Dan committed larceny. So skip C, D, no, because V voluntarily loaned Dan her car. Well, voluntarily, but did he have the intent to permanently deprive when she voluntarily loaned the car? I don't think so. He later on developed it, and then when he decided to not return it, that was when intent was clearly shown. So I would go with A here. Yes, because he did not return the car to V. All right, so this is a long one. Anna, the owner of a nightclub, booked Sam, a famous entertainer, for the week beginning Sunday, July 1st. On June 20th, Sam was stricken by appendicitis and, according to his surgeon, would not be able to perform until August 1st. On June 21st, Anna sent the following telegram to Ella and two other performers. The contents of all three telegrams were identical. So she sent the telegram because somebody that she booked for her nightclub got sick. The telegram said, Sam ill and unable to perform during the July 1st week. Desperately need replacement act. You must arrive no later than June 29th to give the band time to rehearse with you. Money no object as all performances already sold out. Anna. 36 says, assume that Ella received her wire on June 22nd and immediately wired back. On my way, hope I get a better room than you provided last time, Ella. After Ella sent her wire, but before Anna received it, Anna learned from Sam's surgeon that Sam had recovered and could perform July 1st. Anna immediately telephoned Ella and said that Ella was not needed because Sam had recovered. If Ella asserts a claim against Anna and Anna defends on the ground that there was no effective acceptance of her offer, who will prevail? So Ella is saying we had a contract and you try to revoke your offer after we formed a contract and had a meeting of the minds, right? So here we know that the revocation did happen, but whether or not it happened after a formation of a contract or before or after a formation of a contract is the main issue that we have to deal with, right? So when Anna sent a telegram to three people on June 21st, Ella received the wire the next day and accepted her offer, right? And if you think that she didn't accept her offer, I mean, on my way, a reasonable person would understand that in this context, if the person accepting says, on my way, hope I get a better room than you provided last time, on my way. That's like an unequivocal assent to the terms of the offeror. So that shows that there was an acceptance already. So there was a valid contract. And as you know, valid contract requires a consideration and bargain for exchange in which each party suffers a legal detriment. And in this case, one was selling her skills as an entertainer, and the other party was able to pay for that skill. So there was some kind of bargain for exchange. So here, consideration is not an issue. The issue is whether after that they had a contract, when Anna learned from Sam's surgeon that Sam had recovered, found that out on July 1st, which was what, like 7 or 8 days after they had a formation of a valid contract. She called and said, we don't need you because the performer who got sick was able to recover, right? So is that revocation valid? No, it's not, because there was already a contract that was formed between the two parties. So we just have to see if a answer choice reflects what I just said. A says Ella because her acceptance was dispatched prior to Anna's revocation of her offer, and that sounds like the right answer. Right? The acceptance happened, and like 7 or 8 days later, you know, Anna tried to revoke, because that was 7 or 8 days later that revocation was not effective. So A is right. B, Ella, because Anna's revocation was not communicated in the same form as Anna's offer. Well, I think the rule is that as long as it is reasonably similar, right? So that is not a good answer or reasoning behind 36. And we know that Anna is not going to win. So C and D is wrong. But C says Anna because Ella's response failed to specify any salary. And that is, you know, I mean, for UCC contracts, you need to state the quantity. But for service contracts, as long as they're definite terms, I think it's okay. And on top of that, this is not a really good answer to 36. So C is not right. Anna, because Ella's response added a term to the offer which Anna was free to reject. Well, that's not really adding a term to the offer. And, we're not talking about UCC 2207 here. This is not sale of goods. Additional different terms, I don't think that this is it. So the right answer is A. Let's look at 37. Assume the same facts as in question 36. Anna defends on the ground that her wire was not intended as an offer since it was sent to 3 people and she needed only one replacement act. Will this defense succeed? This is a weird, tough question, but to me, it sounds like, will the offeror win after a contract has formed, can she argue that actually there was no contract because the identified offeree mentioned in the original offer was supposed to be three? And if the offeree understood the offer as not just one person being able to accept the offer, but rather three people are able to accept it, then there would really not be any meeting of the minds. Because remember, a contract looks for whether there was a meeting of the minds. And when you look at an offer, the definition is that a definite manifestation of contractual intent, which is communicated to an identified offeree. So I guess what she's saying is that part where a an offer needs to have an identified offeree. In this case, her identified offeree were three people. So but it's saying here that it was sent to three people, and she really needed one replacement act. So, which is a really a bad argument, you know, and a bad question. But I guess what they're trying to get at is if the offeree Ella understood this offer as being made not just her, but to three people, was there a meeting of the minds in this case? And if there were not, then this contract would not be valid. I guess that's the argument that the offeror is trying to make. So let's look at A. Yes, if Anna did not intend to be bound to more than one person. Well, I think that looking at the interpretation of this offer and acceptance, I don't think that the intent of Anna would matter as long as there was a meeting of the minds between the offeror and the offeree. So A is kind of like, it's not really an answer that I like. B is yes, because as creator of the purported offer, Anna's intent not to make an offer prevails. Well, she already made the offer, and later on, this is like saying, in that offer, I didn't mean to say that. You know, what I actually meant to say was something different, and because I meant something different, this contract is not valid, right? I guess this is like an ambiguity issue, and when there is ambiguity, you can use course of performance and other facts that are relevant. But I don't think we want to even go there. I don't think that this is an interpretation issue. I think this is more about whether they had a meeting of the minds. So C would be no if Ella did not know that identical wires were sent to others. So if she knew that this offer was sent to other people, three people, that includes her, that means that they didn't really have a meeting of the minds, right? And that her acceptance wouldn't be an unequivocal assent to the terms of the offer because the terms and the identified offeree is not really clear. So if she did know that there were multiple offers that were made, I mean, I think she still would have a good argument that this was a valid contract, but this is just a weird question. I'm not really sure what they're asking, but I feel like it's asking whether they had a meeting of the minds, and if Ella did not know that identical wires were sent to others, and there wouldn't be any ambiguity, and she would have assented to the terms of the offer, which was unequivocal, saying, I'm gonna do it, and added, extra thing saying, I hope, there's something better this time, And again, this is not the greatest of questions, but looks like C would be the answer. D is no, because Anna would only be bound by the first acceptance she received. That's a really weird answer again. Anna would be bound by the first acceptance she received is a irrelevant type of answer, it seems like. And again, I don't think I would have gotten this right because they're asking whether the acceptance was unequivocal, and they're asking whether the meeting of the minds happened, and whether what the offeree was accepting was what the offeror was offering. And again, this is not a great question, but 37 seems like the answer here is C. You know, again, our goal is to get like a 75 because a 70 is kind of dangerous. You may get like a 69, and maybe they didn't curve it this time, so it may be different. And you don't want to miss this test by a point because first of all, it's expensive. Like it's like what, 1,200, 1,300, and you have to wait another, like 6, 7 months, and that time in between is just painful. So we're trying to get like a 75, 80, and if you feel confident, we're trying to get like 90. But realistically, we're not gonna get every one of these questions right. So we want to just focus on the ones that we feel like we can answer to our best of our abilities. So 38 says, assume the same facts as previous question 36. Anna defends on the ground that Sam's recovery was a changed circumstance that excused her from liability on her contract with Ella. Will this defense succeed? Okay. So she's saying that the fact that she made another contract because her original performer got sick, and in this new contract with Ella, there was no condition or conditional phrase saying, you know, in case my original performer comes back within a specified time, then, we are going to pay you a certain amount, but please know that we are going to go with him when it comes to the nightclub performance. But because they didn't have this type of conditional phrasing in their contract, basically Anna assumed the risk, right? Assumed the risk that she may have to face the fault for getting into another contract with another person. And if she had to cancel this new contract, then she assumed the risk of having to pay out that person or her damages, right? So here, A says yes because the risk of Sam's recovery was assumed by Ellis. Well, she Ellis is the one who was supposed to replace the sick performer, and she was the performer, and there was no mention of assuming the risk by either party. But she's definitely not the one that has to assume the risk because she was contracted to perform, right? And there are no conditional language that forbade her from, expecting to perform and getting paid. So definitely she did not assume any risk. So A is wrong. If anything, it was Anna that assumed the risk by contracting with another performer because her former got sick. And if she was ever going to be in a position to cancel this new contract, then she assumed the risk of being sued for breach of contract. So A is wrong. B is yes, because illness in personal service contracts operates to excuse performance. I think they're talking about like impossibility or like using that to kind of excuse herself from performance, which would really not be available here because there was sh- at the time of contracting with a new performer, she probably knew the risk of or assumed the risk that the former performer would be able to come back. That was not even, it didn't cross her mind, but that's something that she had to have assumed the risk. And now she can't say that, you know, using impossibility, that my duty to perform should be excused. And that's not a good legal argument, which will, work. So B is wrong. C is no because Anna was unilaterally mistaken as to whether Sam would recover in time to perform. Well, using one of the defenses to enforcement, this mistake is not something that would work. You know, I can't really remember the. I know that. Let's see. I know that there has to be an inducement and center, meaning bad faith or knowledge that um, that that something was not well in a way. I can't really articulate it right now, but this is really not a mistake defense type of fact pattern, right? Let's look at D. No, because Anna did not condition her offer on Sam's continued incapacity. Here we go. We talked about condition, and this question is mentioning condition, and therefore the risk of recovery was assumed by her. And this is exactly what we talked about for the previous answer choices. So the answer would be D. All right, so let's look at 39. Assume for this question that there was a valid contract between Ella and Anna and that Sam recovered. Assume further that Anna refused to allow Ella to perform as the featured star, but offered to employ Ella at a salary of $3,000 for the week to perform in a less popular nightclub, which Anna also owned. Ella's usual salary for a 1 week engagement is 5,000, and this is the sum she expected to receive from Anna. Ella refused to perform at Anna's other nightclub and was unable to obtain another booking. Anna paid Sam $10,000 for his 1 week performance. How much is Ella entitled to recover from Anna? Okay, so let's say that, assuming that Ella was able to recover, that would be the expectation damages, which would be 5,000, right? Because Ella's usual salary for 1 week engagement is 5,000. They tell you, and they also tell you this is the sum she expected to receive from Anna. So if we're talking about expectation damages, that's $5,000, right? Now they tell you that Sam was paid $10,000, which is kind of there to throw you off. That's has nothing to do with Anna's expectation damages. Again, and they tell you 2,000, and I guess they're trying to make you choose that because maybe you'll subtract 3,000 from 5,000, which would be 2,000. But knowing that if her expectation damages are $5,000, the issue here is she was whether she mitigated her damages or expectation of damages, meaning, like, if you're suing somebody, right, and once you sue you can't exacerbate your case to kind of sue more. As a person suing, you have the duty to mitigate damages, right? But a lot of times, I noticed that the baby bar or the essay portion, either in essay portion or the MBE, they like to test you on whether a party mitigated her damages, but before being able to mitigate, or while she was offered from the person suing some type of a deal, right? But if that deal is, like, let's say you're expected to get $4,000 to work 1 week at a nightclub, if it was, usually for essays, like if it was somebody offering you like 2,000 to work as a security guard, but your job that was supposed to make you more money was not a security job, and you're, let's say, assume that you're a dancer, they didn't offer you a position that was substantially similar, right? Not only that, they offered you a position that, not as a dancer, they offered you a job as a security guard. So in this scenario, you don't have to take that job because later on, you can tell the judge, I couldn't mitigate the damages because, first of all, there were no other jobs at the time. And second, I'm a dancer, I'm not a security guard. And the judge will go, okay, that's fine. You're expected to get paid $5,000, so that's what you'll get. But let's say that she was offered like a $5,000 job at a nightclub with a different in a different location, like, but not to the point where it may substantially burden her, but it was maybe like 1 mile away. Then, if she decides to reject that offer, she probably breached her duty to mitigate, right? So, counting that, she'll probably, get paid less than her expectation damages because she failed to mitigate. Well, in this case, the person who offered her a job and somebody and the person who promised her a contract to perform offered her a similar job for a lot less money, right? And in an essay, I would probably write that she failed to mitigate, because that job was only $2,000 less. And on top of that, it was at another nightclub, but just with a less people, less popular, right? But I guess for this question, when you're offered a job that is $2,000 lower at a nightclub that is less popular, I guess the the baby bar writers want you to think that that is not substantially similar, so you don't need to take that job, which is very weird to me. But for this question, her expectation damages would be 5,000 because that was how much she was supposed to get paid. And when she was offered 3,000, she had a duty to mitigate. But because it was $2,000 less at a less popular nightclub, she didn't have to take that job. If it was like 4,000 and they said it's a nightclub that is just as popular, maybe her failing to mitigate lessen her expectation damages. But for this question, I guess a job replacement offer that is $2,000 lower at a less popular nightclub is substantially different. Now, I don't know, like, when they would say a scenario in which they say this is something that the plaintiff should have taken to mitigate or should not have taken to mitigate. That's I don't have a clear like number. Like, I can't say like if it was like less than 40%, and if it was you know at a if the new job was offered at another place that's less popular. I don't There's no number that I can work with to kind of teach you or describe to you whether the plaintiff should have mitigated. But for this particular question, that offer the plaintiff did not have to take. So she's able to sue for the entire expectation damages without duty to mitigate. So 39 would be B. All right. All right. That was another one that is just tough. All right. Assume that Frank, another performer, received one of the three wires sent by Anna on June 2nd. Without communicating with Anna, Frank canceled his existing booking for the week of July 1st and appeared at Anna's nightclub on June 29th, stating, "Here I am. You knew you could count on me to help you out." Anna said that Sam had recovered and was going to perform, and that Anna did not expect Frank since she had heard nothing from him. If Frank sues Anna, who will prevail? So this is a question of whether a reasonable person would have understood Anna's telegram that was sent to three people as a bilateral contract. Bilateral contract meaning a promise for a promise. She asked these people to kind of reach out to her by a certain date because they need to rehearse. Just by looking at that, it seems like a performance, a promise for a performance, meaning a person can accept by, you know, showing up before the promised rehearsal time, and that would constitute as a promise to performance contract. But again, even though it seems like a promise for performance, what they're saying here is that her original telegram was not a promise for performance. What they're saying here is she expected some kind of a promise rather than performance, So this is according to 40, what they're saying is this is a promise to promise a bilateral contract. And because Frank, who canceled his existing gig on July 1st, but he received the telegram from Anna on June 2nd. Now, 27 days later, he showed up because his understanding was that this was a not a bilateral contract, but promise for performance. So he showed up, but what this question is asking is he showed up 27 days later and he got rejected, because he relied on that promise. Can he recover if he ends up suing Anna? And what they're saying here is that no, because looking at the situation, it is likely that Anna expected some kind of a promise, a return promise from one of the three, rather than one of them showing up 27 days later. And again, I don't know if I would have gotten this right because it really seems like a promise for performance. The language says that, but I guess considering the entire situation, it's a bilateral contract in which Anna expected some kind of return promise, to her offer, which was sent to three people. And I guess what they're also saying is that looking at the situation, a reasonable person would have interpreted this type of offer as being a bilateral offer in which the person receiving it should have sent some kind of confirmation or a promise that they were going to perform later on. So C would be the answer because it says Anna would prevail because her wire should reasonably have been understood as an offer requiring a timely return promise. Again, they're saying it is a reasonable person who received this type of offer would have understood it as a bilateral contract in which if person later shows up 27 or 21 days later shows up, that's not enough to form a contract because there was no return promise. So that was 40C. Let's see how many we got. Just three more. Alma and Betty were patients in hospital. Dr. Andrews was to operate on Alma for a back problem. Dr. Brown was to perform an appendectomy on Betty. Each doctor was performing her first operation in hospital. Neither was familiar with the location of the operating rooms. Through some unexplained mistake, employees of hospital took Dr. Andrews to the operating room where Betty was awaiting her operation and took Dr. Brown to the operating room where Alma was awaiting her operation. Each doctor commenced operating before the mistakes were discovered, right? So this is that classic consent issue, whereas while you're under anesthetics, the person who was supposed to operate on you didn't operate, but rather another person that you weren't aware of operated on you, and that would be usually a case of battery, right? Because they violated the duty to of informed consent, right? Because you're informed and you consented to a certain person, Dr. A, doing something on your body, but because instead B operated on your body, that would be the classic case of informed consent and classic case of battery, because battery is like harmful or offensive touching with the victim's person, right? And because this is a classic battery case, if Alma asserts a claim against Dr. Brown, she will prevail under battery, which is answer choice A. If Betty asserts a claim against hospital, will Betty prevail? Well, if she can sue the hospital, it would be a negligence case because she would have to prove that they had a duty and she was a foreseeable plaintiff and they breached their duty to act as a reasonable person and would be cause and fact, foreseeability, causation, and damages, right? So here, they would not be liable for a battery because that is an intentional tort. You know, they did not they did not intend to touch her in any way, not necessarily harm, but intent to touch didn't really happen by the hospital, so A is wrong. B is negligence for res ipsa loquitur. So res ipsa, according to my memory, is negligence wouldn't have happened unless somebody was negligent. And to prove it, you have to prove that somebody must have been negligent, right? Because somebody got injured. And second is that the defendant had exclusive control over the instrumentality or the circumstances that caused the accident. So here, she could prove that unless somebody was negligent, her she would not have suffered this harmful touching or offensive touching, and not to confuse that with battery, but under negligence, because that's what she's saying. Let me just. I think the question would have been easier if they mentioned that she got injured, but there's no mentioning of injury, which is kind of what would kind of throw me off here. But it seems like to sue the hospital, they I guess what they're saying is the hospital had exclusive control over not the instrumentality of overseeing what's happened, overseeing the entire procedure and her surgery. And, even though they don't mention that she was injured in this case, and that negligence would not have happened unless somebody was negligent. And I really don't like this answer, but, seems like they like C or B, because they're saying that suing the hospital obviously is for negligence, and although they don't talk about the damages she suffered, she would have a claim against hospital under that theory, right? And I guess C's looking for respondeat superior, but suing the hospital straight for negligence, you don't really need to prove that they were like the employer of Dr. Andrews. So, you know, I guess you could, but when you're suing them for negligence, then it would just be a straight up breach of duty, causation and damages analysis. So B is right. D says strictly liable, and this is not about strict liability. So that is not the right answer, right? Okay, so finally we got 43. Owner brought his television set to repair for repair. Repairer sold the set to buyer. Buyer believed the repairer owned the set. If owner asserts a claim based on conversion against repairer and buyer, owner will prevail against. So, um, y- conversion is like you're depriving someone's right to a property, but you have to have exercise dominion or control over that property, right? Now they say that the buyer was a good faith buyer who had no knowledge of whether this television set was belonged to somebody else. And the thing about conversion is that the buyer had no knowledge that this actually actually belonged to the owner, but nonetheless, as long as the buyer exercised dominion, exercised control over somebody else's property, that would that which would deprive the original owner of their ownership, they can be liable for conversion. I think the main thing here is that conversion is an intentional tort. And in the beginning of my law career, I used to think that, you know, cases like this, the person who took the television set has to have the intent to steal or keep another person's property unlawfully. But interestingly enough, for conversion, all you need all you need is the intent to exercise dominion and control over somebody else's property, which he did because he exercised control and dominion once he purchased this television set and deprived the original owner of its ownership, right? Which she did. So this is a trick question in a way because the buyer had no knowledge, had lack of knowledge of whether this television set was even stolen, was the legal property of the seller. But that doesn't matter as long as that television set was he had sufficient dominion or control over that television set, which he did when he purchased it from the seller, which deprived the owner of its possession, right? So obviously, the repairer would be liable because he was satisfied the both elements. And the trick question as for the owner, the buyer, he would also be liable because he exercised dominion over somebody else's property, which was the television set. And I don't like this. And that's why in the beginning of this video, I told you that they really love to test you on how how each element of each black letter law would apply in certain facts or scenarios, which means that you have to really, really know, like whether you know it would fit under certain circumstances, and unless you just keep practicing, and unless you keep exposing yourself to more of these questions, you're not gonna get a feel for it. And I think the most important thing about MBEs is that you develop a feel for it after doing so many that you know what they're going to ask before even getting to the call of the question. And you know you do so many that any more MBEs you do just seems a repeat of what you've already done. And that's where I'm trying to get you to be at, because there's no shortcut to getting these right. You just have to do as many as you can and practice. And if you get them wrong, go back and go over the black letter law. You know what specifics that you missed, your understanding of how it can be used may have been a little bit distorted. But this is another good opportunity to kind of straighten everything so that later on when you practice, you can really use these you know different concepts to further your client's position. And it may be really tough now because you have to keep correcting yourself. But again, I want to tell you that it's all for your benefit. And once you start getting good at it, then you'll really know how to utilize all these and use them at the right situations and scenarios, which will make you a better attorney or you know better practitioner of law. So with that, this was another long session, and I appreciate you for watching. And hopefully, in the next 4 or 5, maybe 6 videos, we can finish out the rest so that you can benefit from these videos and help you pass the baby bar exam that you're going to be taking soon. So, with that, again, thank you, and I'll see you in the next video.